I'm Reed Bloodworth, the managing partner of Bloodworth Law, with offices in Orlando and Winter Haven, Florida. One of the most common business disputes we see is a breach of contract. So what happens if you're sued for breach of contract and need defenses in a Florida contract dispute? It's not enough to simply deny any wrongdoing on your part if you're accused of a breach of contract. You must assert defenses. There are a number of defenses, known as affirmative defenses, which in Florida must be claimed in your answer to the lawsuit, or your ability to raise those defenses may be considered waived. When a party to a contract fails to perform their contractual obligations, the injured party has a right to file a lawsuit for breach of contract. A breach of contract occurs when any act or omission of a party does not live up to the promises exchanged in the contract. Oftentimes, it's not even relevant as to whether the breach was intentional or unintentional. In order to win a breach of contract claim in Florida, a party must prove 1. There was an enforceable contract, 2. A contractual promise was broken, and 3. The broken promise caused damage to the pursuing party. It's important to know that in a breach of contract, a plaintiff must prove all 3 elements to win. But a defendant needs only prove one element wasn't satisfied to prevail on a breach of contract claim. A defendant in a breach of contract claim in Florida has 20 days to file a response. If a defendant denies all a plaintiff's claims, the plaintiff has the burden of proving their case. The standard of evidence in a breach of contract claim is by a preponderance of the evidence, which means more likely than not these things happened. In addition to denying the allegations in a breach of contract, the response should also include affirmative defenses. An affirmative defense does not necessarily deny the claims made by the complaint. Rather, an affirmative defense states the reasons why these defendants' actions were permitted and why the plaintiff should not prevail. A defendant has the burden to prove an affirmative defense by a preponderance of the evidence. There are many defenses to a claim for breach of contract. A few common defenses include statute of limitations, fraud and inducement, duress, impossibility of performance, illegality, mistake, and unclean hands. Statute of limitations means that the time to file a complaint for a breach of contract has expired. If a claim is filed after the statute of limitations is passed, that claim will be barred. And the statute of limitations for a breach of contract claim is 5 years for a written contract, 4 years for oral contract, and 1 year for specific performance of a contract requiring a party to perform a specific act. Fraud and inducement means one party to the contract was deceived into entering into that contract and that was not in his or her best interests. Duress means that a party was forced into signing an agreement against his or her will. Impossibility of performance means one party cannot perform according to the provisions of a contract because of an unforeseen incident like an act of God, death, incapacity, property destruction, etc. Illegality means if a contract violates state or federal law, then the contract is void. For mistakes, there are unilateral or mutual mistakes. A unilateral mistake means that one of the parties to the contract did not understand what the contractual agreement was. A mutual mistake means that both parties to the contract did not understand the contractual agreement. A contract is void if the parties entering into it were mistaken about the terms of the contract. Finally, an unclean hands defense is where a defendant claims a plaintiff is not entitled to relief because the plaintiff has done something wrong. Conduct that constitutes unclean hands may include failure to perform under the contract terms, fraud, coercion, committing a crime. Business owners seeking to protect their business interests should seek a qualified, competent advisor for assistance. Again, I'm attorney Reed Bloodworth, the managing partner of Bloodworth Law. If you have a breach of contract dispute, give me a call. let's talk about how Bloodworth Law can help you or your business.